Hello and welcome to the third part of this employment law webinar from Field Seymour Parks. My name is Ian McRae and I head up the employment law team here. And essentially in this section we will be talking about the general data protection regulations that are incoming and what employers need to be doing now in preparation for them. So these are European regulations that are due to come into effect 25th of May 2018. But the nature and the implication of these regulations is that employers and organisations need to be taking steps to ensure that they're going to be in compliance and they need to be taking those steps now. Often get asked the question on these in that obviously Brexit is due. And therefore there's been an assumption that we don't need to be concerned about these. Well, there's a quote there from the current Information Commissioner, Elizabeth Denham, and using Theresa May's words, but in a slightly different context, she says, "I don't think Brexit should mean Brexit when it comes to standards of data protection." And essentially there is an indication that Brexit or not, we are likely and indeed we're going to be bound by these regulations or very similar regulations to them, and there is a commitment to that from the government. Timing wise, equally they're going to come into force at May next year. Brexit will not be taking place until 2019 at the earliest. So this is something that employers need to be preparing for now. Equally, as we'll come on to, because of the scope of these regulations, if businesses are going to be coming into contact with the European Union, it's highly likely they'll need to be compliant in any event. So we can't just ignore these on the basis that we will be leaving the European Union. So it's quite important, I think, for me to highlight the scope of this webinar and what I'm going to be focusing on today. So I'm going to be looking at the HR and employment implications of the general data protection regulations. But it's fair to say, particularly for some companies, the implications of this are going to be a lot wider. So these regulations are going to apply not just to personal data about employees, but also about customers, suppliers, contractors, and any manner of personal data which is held or processed by businesses. And as such, it is going to require input from not just HR, but also from IT and indeed management and legal to ensure that companies are compliant. What I'll be focusing on today is particularly with reference to the challenges this creates from an employment and employee point of view. So the intention behind these new regulations is to ensure greater harmonisation across Europe, essentially to make it easier for businesses to carry out businesses across different jurisdictions. And there's also an expanded territorial scope to the regulations. This is the point I was getting at a little bit earlier. In that companies are going to be bound by these if they offer goods or services to basically people in the EU, or that they are monitoring people in the EU's behaviour. So even if you're not based in the European Union, if you are looking to do business with individuals or companies in the European Union, or you're going to be processing data, personal data about people in the European Union, you're going to be caught and you're going to be expected to comply with these regulations. So let's have a look at some of these changes. Essentially, these regulations are going to be replacing the Data Protection Act, which most of us are familiar with. And what it does is build upon those general principles and essentially give them more teeth and give them a wider scope. Firstly, there's increased enforcement powers. So the current cap on fines is £500,000. That's going to increase to up to 4% of annual turnover or 20 million euros, and it's the greater of those. So whilst £500,000 may sound like quite a lot to a lot of companies, to some obviously it's just a drop in an ocean. And that's the purpose of this increase in fines, is to ensure that there is an adequate remedy for all organisations to be taking these serious, regardless of size. This is an important point, bearing in mind our HR employment angle that we're looking at in this webinar. And this is the idea that consent to holding and processing personal data is going to be much harder to obtain. So firstly, you need clear affirmative action. They shouldn't just be relying upon an implied acceptance or an implied consent. And there'll be a burden of proof, essentially on the employer, to establish that it has obtained an adequate consent. The consent also needs to be specific. So if data is going to be processed for more than one purpose, so for example, for payroll purposes, for contractual obligations, for some other legitimate business interest of the employer, each of those purposes will need to be stated and specified. A general sort of catch-all and general consent is not going to be effective. Consent also needs to be informed. So the individual giving that consent needs to understand what it means and also their own rights in respect of the data that is held and processed about them. Now, this is a particular problem for employers, and essentially consent needs to be freely given. Now, what the regulations indicate that if there is an imbalance in the relationship between the parties, then consent will not be freely given. And the likelihood is that the employer-employee relationship is always going to be seen as one where there is an imbalance in favour of the employer. And that could mean that whatever consent that you are getting is not deemed as freely given. There's a further major issue with relying upon consent for the processing of personal data, which is that it can be withdrawn at any time. So even if you've gone through all the steps and you've obtained your valid consent, what are you going to do if that is withdrawn at a future point? Now, what this really means is that businesses and organisations need to be looking at alternatives to relying upon a basic consent from employees for the processing of their personal data. So they need to establish another legitimate or more than one legitimate grounds for holding and processing the data that they have. So I'm just going to give you a few examples here. There are plenty more, but is there a contractual necessity to hold or process that data? Is there a legal obligation? For example, your regulatory obligations or indeed your obligations under all the different aspects of employment law? Or are there other legitimate interests that are sufficient to justify the data that you're holding and processing? There's also an issue, I think, for employers in particular relying upon deemed consent generally. And what I'm getting at here really is job applications. Now, currently, employers will rely upon maybe just an implied consent for the processing of that personal data, or will just rely upon a very sort of loose and unspecific consent. That's not going to be sufficient going forward, and employers are going to have to review their practices, not just in respect of their current employees, but in respect of how they deal with job applicants' personal data. And obviously that could create a much wider class of individuals. The regulations also provide that certain organisations must have a designated data protection officer. That will include public authorities. It will include employers who have 250 or more employees, and also those who are systematically processing data. So if any of those apply, you will need to have a dedicated data protection officer. There's also going to be some changes to data breach notifications. So the current law on this area is that the majority of data breaches, it's not mandatory to report them. That's going to change, and it's going to change so that not only do they need to be reported to the Information Commissioner, that they also need to be done so within 72 hours. There's also going to be a right for people to have the ability to be forgotten, so essentially the deletion of personal data about themselves. What we're probably quite familiar with is this idea of data subject access requests, but now we're going to have the right for people to say, I don't want you holding that information about me, and it needs to be deleted. In addition, we do have changes to those very data subject access requests, and we're going to look at those points now. So The deadline is going to shorten down to a month rather than 40 days as it currently stands. And the organisation, when giving out the personal data it holds, is going to have to give a lot more information. It's going to have to give identity and details of data controller and data protection officer. It's going to talk about the intended purposes of the processing of that data, period for which data is going to be stored, explain the rights of that individual in respect of the deletion of that data, explain the right for them to make a complaint to the Information Commissioner if they're not happy with how their data is being processed, explain how that information and to whom that personal data may be disclosed, and any intentions to transfer it to a third party, and then this catch-all of any further information necessary to render the processing fair. Now, I flag up the issues with data subject access requests in a little bit more detail because often dealing with these can be very onerous for organisations, and these changes are essentially just going to make it more onerous. And what it means is that businesses have got to be set up and ready for these regulations and indeed any subject access requests that are brought, because there's only going to be a very limited period of time in which to comply with it. So let's look at what you need to be doing about this now. Well, essentially, you really need to be carrying out an audit of the personal data that you hold. Now, I'm focusing here on HR and employment and employee data, but that should go wider than that, and you'll be needing to look at all the personal data that's held within your organisation generally. But in terms of the HR data, you need to be looking at what you hold, why you hold it, what's the legitimate basis for holding it. If historically you've just relied upon consent, what are the alternatives to that moving forward? What other legitimate basis can you establish? And how long are you retaining it for? Ultimately, you need to be establishing that there is a reason, a good reason, for what you are holding, that you are processing it in a manner that is proportionate to that, and that you're not retaining things for longer than is necessary. And you can only start to assess those things when you actually know what you hold. You are going to need to review, update, or indeed replace the privacy notices that you issue. You're going to need to revise your policies on reporting data breaches and how to deal with data subject access requests. And you're going to need new data protection policies in place to ensure that you are compliant with all of the principles in these regulations. And as part of that, you are likely going to have to want to look at your contractual arrangements. And by that, I mean not just your employee contracts, although they will need review as well, but also your contracts with suppliers, contractors and third parties to ensure that you are making sure that they are complying with their obligations as well. Training could well be important, and that may just be key staff to ensure that they're aware of the obligations that the organisation now has, or could go wider than that to ensure that all employees are making sure that they are handling third-party data in an appropriate way. Data protection officer, as I said earlier, you need to assess whether you need to appoint one if you haven't already got one in place. So a few final points there. Usual caveat applies to this webinar in that this is only a brief introductory summary. This is quite a complex area of law and would strongly recommend you get some advice on how to comply with the general data protection regulations, which will differ from organisation to organisation. If you're interested in the free employment law updates that we offer, then please just drop me a line and I'll send you an example to see if it's of interest. And equally, if you want to hear about future events or future webinars, again, drop me a line and I'll provide you details. Love to hear with any feedback, and my email address and direct line are there. And if you haven't already done so, there are 3 other sections from this webinar dealing with employee status, holiday pay and gender pay reporting.